Welcome, everyone. My name is Andrew. I'm the founder and owner of IBIS Prep, and this is the last class for the February 2026 bar exam, and we're working with the MBE. We're going to start with the Cram guides because down the stretch, there's nothing more important than Cram guides. Cram guides, Cram guides, Cram guides. So this is the master Cram guide that we'll start with, and you can see it goes by subject, it goes by contracts, and then it goes by torts, and then it goes by uh, con law, and then real property, and then civil procedure, and then evidence, and then crim law, crim pro. This is the best resource that you could find for studying for the MBE because it's just correct answers from previous practice questions and the key takeaways, right? So highly recommend you go over this. It's 47 pages, but you'll see by the end of this class, it's going to be extended because I'm going to add the February 2026 cram guide to this master cram guide. So it's going to be the most masterful it's ever been. So I would go over, this, just read it and just try to shake your head. Don't try to stress out too much. If there's a point or two that confuses you, just move past it. But really, it's for reinforcing and refreshing the concrete, cold, correct answers that you're going to see on test day because we're going to train the brain here just like it's a muscle, right? So with this cram guide, there's a lot of subjects, but then we get to the all subjects. So that's where I'm going to start today. I'm going to do some of the all subjects reviews, and then we're going to do some questions together. All right, let's talk about them. So a person cannot be convicted of both larceny and robbery because the lesser crime of larceny merges into robbery. A person can be convicted of either, but not both, right? Merger doctrine. A person who takes a purse with the intent to steal it has committed larceny, even if moments later they decide not to take it and they haven't even left the store. That's the majority jurisdictions, how they see larceny. That once you have taken an item with the intent to steal it, larceny has occurred, even if you then have a change of heart and decide to give it back. An agreement is enforceable if there's been formation and a subsequent recordation is not necessary, and lack of one does not preclude enforcement. So if two parties agree to something, there's an agreement. Just because you didn't subsequently record it doesn't matter, unless, of course, it had to conform with the statute of frauds, then it would have needed to be in writing. But if it's a valid oral agreement, then the subsequent recordation is not for the purposes of contract formation. It's just for their records. So laxatives are not poison, and intending to cause someone mere discomfort is not intending to cause great bodily harm sufficient to constitute murder. So yeah, there's a question about poisoning, but it's laxatives. Laxatives are not poison. They didn't have the specific intent for murder, and it wasn't sufficient enough for intending to cause great bodily harm because it was just mere discomfort. A product could be defective if there's an alternatively safer design. For example, if a car stalls but could have been designed not to, this could be a design defect. In determining the burden of electronically stored information, the judge should consider the likely benefit of the material to the respective case, the needs of the case, the amount in controversy, the parties' respective resources, and the importances of discovery and resolving the issues. A case is not removable to federal court because the defense has a federal question. The federal question must be raised in the complaint, or there must be diversity. Furthermore, just because a plaintiff could have raised a claim under federal law is not important. The issue is what claim was actually brought. So they test that a lot. Like just because there's a federal question in the defense, that's not enough for federal question jurisdiction. There has to be a federal question in the face of the complaint. A motion for relief from judgment for newly discovered evidence that could have been discovered earlier can be brought up to 1 year from the verdict. It's considered new evidence if an attorney overhears that the jury was biased and votes based on disdain for the lawyer and the teacher because this would be considered juror misconduct. So motions for release from judgment up to 1 year after the verdict, unless it's a clerical error or fraud on behalf of the court, those can be brought at any time under reasonable time. But most things for relief from judgment can be brought 1 year after the verdict, like newly discovered evidence or fraud on another party or something like that. Laws targeting low-income housing are subject to rational basis, and the plaintiff has the burden of proof to show the law is not rashly related to a reasonable/legitimate government interest. Strict scrutiny narrowly tailored to a compelling government interest and the burdens on the government. For example, an ordinance allowing picketing for one subject but banning picketing for all other subjects is content-based and subject to strict scrutiny. So strict scrutiny for content-based, intermediate scrutiny for content neutral, time, place, and manner, but it's heightened intermediate scrutiny. It's narrowly tailored to an important government interest, substantially related, and leaves open alternative means of communication. So we say heightened when we add the narrowly tailored part in front of the ordinary strict or intermediate scrutiny language. Another form of heightened intermediate scrutiny where they add the narrowly tailored language is restrictions of commercial speech. Now, if it's false or misleading commercial speech, it gets no constitutional protections. The president must spend money as appropriated. For example, if an Appropriations Act allocates money for wildflower planting, the president cannot spend money on training the troops and or retain the money in the treasury. He has to use the money as appropriated for. Impermissible character evidence using 3 prior incidents of resisting arrest to show that someone likely conformed with the behavior in a civil case today. So we can't bring in prior incidents to show likelihood of conforming with the act today, right? We can maybe bring it in for other purposes, for motive, intent, mistake, lack of mistake, identity, common scheme, or plan. We're not going to be able to bring it in to show conformity. A state can enact legislation that would otherwise violate the Dormant Commerce Clause if the state is explicitly authorized by federal law or Congress. Remember, 2 very common exceptions to the Dormant Commerce Clause are express authorization by Congress and the market participant rule. If the state is participating in the market, then that's an exception to the Dormant Commerce Clause. Summary judgment is appropriate after discovery. JMOL is appropriate after the opposing party has presented its evidence during trial, right? So JMOL either after the opposing party is presented or after the opposing party is presented, then you presented. Like as long as the opposing party is presented, you can bring a JMOL. But if only you've presented, then you cannot bring the JMOL until the opposing party is presented. Blasting is considered an abnormally dangerous activity that triggers strict scrutiny and is thereby a non-delegable duty. The court may order a man to walk to see if he has a limp without violating any constitutional rights. On the MBE, assume pure comparative negligence. Any plaintiff harm can recover even if 99% of fault and joint several liability. The plaintiff can recover the entire amount minus his or her fault from any defendant. If the jurisdiction is pure comparative fault and is abolished joint and several liability, then the plaintiff can only recover the percent each defendant is at fault individually. So they'll tell you if they've abolished joint and several liability or if it's common law, which is contributory negligence, which means that any amount of negligence is a bar to recovery unless it's the last clear chance doctrine. And then modified or partial comparative fault means if a party is over 50% of fault, then they're barred from recovery. But you assume pure comparative fault and you assume joint and several liability, where the plaintiff can recover the entire amount from any defendant. If a defendant is found guilty of second-degree murder in a trial where they're also accused of first-degree murder, they're implicitly acquitted of the greater first-degree murder charge and cannot be retried for it, right? So that's double jeopardy. You were convicted of second-degree murder. We can't come back and then charge you of first-degree murder after because you were implicitly acquitted of the higher crime by being convicted of the lower crime. Evidence of photographs of a crime scene that would help an expert are likely admissible because they're relevant, right? As long as someone can say that the photograph is what it purports to be. A judge may impose sanctions on an associate if he comes to pretrial conference substantially unprepared and is squirming. A renewed JMOL may only be made if a JMOL was initially raised, right? Easy question to get. If you see that they haven't raised the initial JMOL, they cannot bring the renewed JMOL. For new JMOLs, we have 28 days after the verdict, new trials, 28 days after the verdict, appeals, 30 days after the verdict. So Semtech, under federal application, court should apply the preclusionary effect of the court where the first case was decided, which may have been a state or federal court. So if it was a state court decision and now they're trying to refile, the question of whether non-mutual issue preclusion is allowed depends on whether the first court state would allow it or not allow it. So that means that even though preclusion is a procedural issue, federal common law says to use, and this is what Semtech ruled, the preclusive effect of the first court where it was filed. So if they're saying, can they use non-mutual issue preclusion or offensive or defensive issue preclusion? The question is the first court where it was filed, what's their position on whether or not you can use these types of preclusion? If they allow for it, then that's how it'll be determined. So the preclusive effect of the first court where the case was filed is going to be what applies. So it could be state court or federal court. It's just the first court where it was filed. So rule against perpetuities, that's your favorite thing. No interest in land invalid unless it must vest, if at all, within 21 years of the death of a living being at the time the interest was created. So if a conveyance is to Tommy for life and then to Tommy's children, but Tommy doesn't have any children at the time of the conveyance, then this does not violate RAP because it's certain to either vest or not vest. Either there will be kids or it will not be kids, right? Just because there's a contingent remainder does not mean it violates rule against perpetuities. Rule against perpetuities means there would have to be, if Tommy already had a kid and then it says to Tommy's kids who reached the age of 30, right? That would be like, well, everyone could die, and then except for the one kid, and we're gonna have to wait because he's only 2 years old now. If he's gonna reach 30 or not, it would not vest, or it would vest or not vest within 21 years would not be the case. So, rule against perpetuities questions are tough. My advice to you is don't pick it unless you're sure that it's true, because usually it doesn't violate the rule against perpetuities because, like we said, either they'll have children or they won't have children. So at the time, the life estate ends, either it'll vest or it will not vest. It's not going to be 21 years after the death of the life in being. Here's a trick that you guys can learn. Rights of first refusal will automatically violate the rule against perpetuity. A right of first refusal means if A sells property to B, but A says if B ever sells the property, A has the right to buy the property back, let's say at the market price. That right of first refusal will automatically violate the rule against perpetuities. That's probably where I would pick it if you see it. Otherwise, I mean, I'm not saying it won't violate the rule against perpetuities, but you have to ask yourself, is it possible that the measuring life dies and now more than 21 years will pass before we know if it vests or not? Don't get caught up in it. Only reason I put some attention on it is because when I studied for my first MBE, my real estate professor began the lecture by saying, I'm not going to teach the rule against perpetuities. It won't be tested, so don't worry about it. And then the very first question I got on test day, the rule against perpetuities was an answer choice. And I was like, I must be taking the wrong test. Like this is some sort of cruel joke. But like I told my class before the recording begins, there's going to be hard questions. If there's hard questions, just do your best and move forward. Just know that it was hard for everyone. It's not a test where students are expected to get 94%, 96%. So you just need a passing score. So don't get down if there is a question that's outside your wheelhouse. All right, so a unilateral contract can be accepted by performance, and once performance has begun, the contract has been accepted, such as beginning the work for a legal agreement, right? Once you start performance of a unilateral contract, then the contract has been accepted. I'll pay $100 to whoever paints my house. Once I start painting the house, I have the right to finish. An officer may be given a transcript to refresh his recollection, and this does not require the transcript to be admitted under the best evidence rule, right? It could be read into evidence by the opposing party, but it's not going to be admitted as an exhibit because it's just refreshing the recollection, and anything can be used to refresh recollection on stand, even a bowl of spaghetti. Parole evidence will not allow admission of evidence to contradict written terms. For example, if a contract is for $110,000 and both parties agreed, we will not allow oral evidence that was $100,000. So this is an example when parole evidence is barred. I tell students, try to think of reasons why parole evidence could come in. Is it a condition to contract? Does it show defect in formation? Does it clarify an ambiguous term? Is it a way of showing custom trade or usage? Is it a way of showing an additional term? If it's any of those things, then it could come in. It only cannot come in if it's truly contradicting a term of the contract. PJ can be accomplished via minimum contacts, and it's proper to submit affidavits to show lack of PJ. Venue is appropriate where the cause of action accrues and where any defendants reside if they are in the same state. Just because there's another proper venue does not mean that it must be brought there. It just needs to be brought where the venue is proper, right? So yeah, where the cause of action accrues or where the defendants reside, if they're all in the same state. Arson requires malice, which is less specific intent, but more than mere negligence. For example, if a guy sees a flame going towards a house and can stop it, but decides not to because he wants the house to burn, this is arson. Or it just requires malice for arson. It's less than specific intent, but more than mere negligence. Exclusive right to list, the broker must procure the buyer for commissions. Exclusive right to sell, the broker gets paid if the property sells. So if you're a broker, you want exclusive right to sell. Ready, willing, and able buyer must be at the asking price, not $1,000 short. So if you procure a buyer for $1,000 short and the seller doesn't take it, then there's no right to commission, even if he later sells it afterwards, after the listing period ends for that same price. Erie applies to diversity cases, not federal questions. In Erie case, privileges are a substantive issue. In a federal question case, we apply federal procedural and federal substantive law, right? Because if it's federal, then you're going to apply federal procedural and federal substantive. If it's a diversity case, then you apply federal procedural law and the substantive law of the state where the federal court is sitting. And if that state has a choice of law, then you're going to apply that state's choice of law provision. Yeah, that would be the case. There's no federal common law recognition of a physician-patient privilege, right? Earlier when I was talking about the Erie thing, it's Erie doctrine that says the substantive law of the state where the federal court is sitting, and then the Claxon doctrine that says the choice of law of that state, if there is a choice of law provision. A lost volume seller is likely not operating at full capacity and has inventory. Therefore, a breach of non-acceptance would not give rise to damages for the whole contract price, but just the lost sales profits. So the difference between the contract price and the market price, the difference between the contract price and the resale price, or the anticipated profit on the original sale, not the whole contract price. Why? Because it says they're a volume seller, meaning that they have a bunch and people are buying them. So it's not like they're not going to be able to make the sale again, but they would be doubly enriched if, you know, it's they're getting paid twice on the same unit, right? If it says no one else will buy this thing, then you could get the whole contract price. But if it says they could easily resell it, they sell a bunch of these, they're apples in a grocery store, then you wouldn't get the contract price. You would just get the lost volume, right? You would still get something because they lost a sale, but you're not going to get the entire underlying price of the good because it's a volume sale. So if someone is hit by a flower pot from a balcony, they have to show which balcony it was. They cannot sue all the balcony owners for joint and several liability. Party opponent admission is not applicable if it is a former employee statement, right? It has to be a current employee to be a party opponent. Prior testimony is not admissible against the defendant. The defendant was not a party at the previous case and did not have a chance to develop the testimony by direct or cross-examination. So prior testimony is not admissible against the defendant if they're not a party to the previous case and did not have a chance to develop the testimony by direct or cross-exam. Earnest money is not necessary for land sale contract as the regular rules of consideration will apply, right? A promise for a promise. A motion to strike should be filed before reply if the defense include irrelevant material. In a race notice jurisdiction, if there are two parties and neither BFPs, first to record will prevail. The rule that a psychiatrist cannot pontificate upon the mens rea element of a crime applies in criminal cases, not civil cases. So the psychiatrist can't say, I think he was afraid for his life at the moment of the killing in a self-defense, right? Because that's an element of the crime in a criminal case. Federal common law applies for claim preclusion, issue preclusion. That's what I said. So it is, the preclusive effect is federal, right? Procedural, but it's federal common law, and federal common law instructs us to use the preclusive effect of the first case where the claim was filed, the first court where the claim was filed. As far as the preclusive effect of involuntary dismissals, federal courts will adhere to whatever effect the involuntary dismissal would have in the state in which it is sitting. Statements made by the declarant that serve as circumstantial evidence of the declarant's state of mind are not hearsay. For instance, we can allow a defendant to testify that he didn't hire a woman because of her abilities, not her age, in an age discrimination lawsuit. Mere allegations will not support a motion for summary judgment. You should consider a motion for more time for discovery to determine essential facts. I like that answer choice. Whenever they say they should move for more time to find the essential facts, that's usually a good answer. So, not always pick it, right? Don't ever just pick an answer because you think that's always the answer. That's never the move. You should have some justification for it. But if you're totally at a loss, I do recommend picking the answer that's been a common answer in practice, right? Because the actual questions are a lot like the practice questions. A criminal statute can establish a duty of care for negligence per se. For example, a statute requiring a sprinkler system. Even if it's a criminal statute, it still can establish a duty of care for negligence per se. You do not have a duty to protect your neighbors from sunlight, so there's no claim of action if you tear down shade. Contributory negligence is a full defense, and the jury answers instructions saying that the plaintiff was contributory negligent. Judgment must be entered for the defendant, right? Because it has to follow the instructions. The standard for relevancy is whether evidence has any tendency to make a fact of consequence more or less probable. Attempted murder is a specific intent crime. Therefore, playing chicken with the car to scare someone is not sufficient. You cannot sentence a juvenile to life without parole who is convicted of a non-homicide offense. Good rule of law right there. Newspapers are self-authenticating. A regulatory taking occurs when the owner has been deprived of their investment-backed expectations or deprived of economic viability of the land. If a party breaches a contract, the other party must mitigate losses. Um, the question they ask is like, do you have to get a different job? You have a job as a teacher, and there's another job available as a teacher. You don't have to take that job. If you don't take the job, you can only get the difference in the prices. If you do take the job, you can only get the difference in the prices. The key takeaway is if there's another comparable job, whether you take it or not, you can only get the difference in the salary. Now, if you have a job as a teacher for $50,000 and there's a job as a librarian for $50,000, you don't have to take it. And if you don't take it, you're entitled to $50,000. But if you do take it, you're entitled to nothing because you got that same salary and you can't be doubly enriched. So make sure you can understand that thought process. So if A breaches a contract, the other party must mitigate losses. If a party breaches a contract, the other party must mitigate losses. Anti-commandeering, they cannot force states to enact laws about drugs in school zones, right? They can only do conditional funding. If you don't change the laws about drugs in school zones, we're not going to fund your roads, right? Liability insurance is admissible to show ownership responsibility. Subsequent remedial measures are admissible for ownership or control as well. Also for showing the you know potential or possibility of an alternative design, right? A prox liability case can arise due to failure to warn, for example, not warning properly the need to put special tires in order to drive a car much faster than the speed limit. Issue preclusion is narrow, actually litigate essential to the judgment. Claim preclusion is broad. It has to be the same parties, same claims, same configuration. Non-mutual issue preclusion means at least one party is the same. Mutual issue preclusion means both parties are the same. Defensive issue preclusion is used by the defendant. Offensive issue preclusion is used by the plaintiff. Really good stuff right there. Remember that non-mutual issue preclusion is only allowable if the jurisdiction provides for it, and if it is claim preclusion, it always has to be the same parties, the same configuration. Only if it's their privies, like an employer-employee, are considered the same party for claim preclusion. For issue preclusion, a landowner, a subsequent landowner, are considered the same parties in terms of privy analysis. Co-conspirators are liable for foreseeable crimes and furtherance of the plan. It's too late to withdraw or abandon if you already dropped the robber off at the bank. Felony murder killing occurs during the commission of a crime. A co-felon cannot be sentenced to death if he or she wasn't the killer intending to kill, or at least a major participant in the crime. Right? So we can sentence the juvenile, right? We did the question earlier about the juvenile. Let me see where that one was. And then this one is about the co-conspirator. These are both really good points, just like key facts to know that you can get the question right if you see it. So you cannot sentence a juvenile to life without parole who's convicted of a non-homicide offense, right? So the juvenile can't get life without parole if they're convicted of a non-homicide offense. And then a co-felon cannot be sentenced to death if he or she wasn't the killer intending to kill, or at least a major participant in the crime. There's a federal right to a jury trial for matters at law, legal and monetary damages, or certain actions that were available at law before the Constitution, like writs of ejectment, for example. So this is only for federal cases, not for civil cases, that you have the automatic right to a jury trial for legal or monetary relief under the Seventh Amendment. Battery is a dignity tort. An offensive touching is all that is required. Sending someone a rat poison cake amounts to battery, and there's no need for foreseeability analysis. The offensive touching does not need to be personal. It can be sending the rat poison cake or pulling away the chair. Some of y'all would rather eat a rat poison cake than take this test, but you gotta do what you gotta do, right? Routine business practices are admissible. For example, a person can testify about the habits of the mailroom people collecting mail. A police officer may reasonably rely on a defective warrant, but may not rely on information he knows to be false. If a contractor does work but doesn't pay the licensing fee that is merely to raise revenue, the homeowner cannot refuse to pay the contractor as a loophole, because the purpose of the licensing fee is not to protect homeowners. So that's a good answer to a question, that it was merely to raise revenue, so they're not going to be able to get away with paying the contractor because they want the protected class. Concurrent tortfeasors are jointly and severally liable for the damage they cause. For instance, if two companies pour chemicals into the water. Deposition must contain description of matters of examination. If a vague depo is served on a corporation and requires the president with no information of matters for examination and presence says she had no personal knowledge of the matter, she may seek a protective order against the depot as the basis of the device is being used to harass. Once the deed is transferred, ownership has ceased for the grantor. Transfer occurs when there's intent for the deed to leave the control and dominion with no exceptions. Look for that answer choice, that the deed was not transferred because it didn't leave their control or dominion. No directed verdict if a reasonable jury could decide either way. For instance, an expert attests to a jar shattering that seems to be a defect, the jury could decide either way. If you're on the fence, hey, so is the court, so send it to the jury, right? Directed verdict would be the same as a JMOL, right? No reasonable juror could find for the non-moving party, or there's sufficient evidence in favor of the moving party. The Sixth Amendment applies to criminal cases, right? So your right to counsel after adversarial proceedings have begun. The Seventh Amendment is for civil cases. Seventh Amendment is federal only. That's your right to a jury trial for cases at law. States can enact the legislation to guarantee jury trials in certain cases. If it's a state case, then apply this law, right? So yeah, you apply the state law in state cases. If both parties are mistaken, reformation is a proper remedy, so could potentially be rescission. Parole evidence does not exclude admission of a mistake or defect information or condition of contract or clarify ambiguous terms or add additional terms, just not to conflict the fully integrated contract. Like we saw one earlier where the terms were different in the prices. Article 3 requires either federal question or diversity, and Congress cannot legislate to circumvent the diversity requirement, right? And then remember the fixed jurisdiction of the Supreme Court for cases involving a state or cases involving ambassadors. If the bridge is complete and you're suing for injunctive relief, the case is now moot and you cannot sue, right? Mootness is too late. Ripeness is too early. If it's not ripe, it's too early. Once you have probable cause, you don't need a warrant, and people rushing around throwing things out amounts to exigent circumstances. It's okay to have barbed wire because that's apparent around property that people intrude to hunt, right? It's open and obvious if you get injured by barbed wire. The best objection to a failure to object is that the party's substantial rights were plainly affected, right? That's a good answer. If your substantial rights were plainly affected, you can get a new trial, right? Even if you fail to object to something, it's something very important if they had their substantial rights plainly affected. You can't impeach a witness based on collateral matters if they get some small detail wrong. If a law is general and not targeting religion, it is applicable, right? So it has to be targeting the religion, not just have a negative effect on them. Federal agencies must spend monies as directed by Congress, right? Appropriations. If you repudiate a contract and the other party's reasonable line of repudiation and make a separate deal, it's too late to cancel repudiation. Evidence is relevant if it has any tendency to make a fact more or less probable. If a woman tried to poison her husband to death, but he doesn't take a sip of the drink, this is still attempted murder because the requisite steps have been taken toward attempt. If the maid drinks the poison glass that the husband set aside, the wife can be convicted of murder, depraved, or at least voluntary manslaughter. So yeah, the woman would be convicted here of attempted murder of the husband and, probably murder, depraved heart of the maid. Can't just leave out cups with poison in. The state may not force a private club to include members who oppose the club's sincere mission. That's the Boy Scout case. Children doing adult-like activities will be held to an adult-like standard of care. For instance, a dumb kid driving a car. An amateur skier who caused an accident would be held to a standard of care of an ordinarily prudent skier, non-ordinarily prudent amateur skier. I added this question because I did this personally and I got this one wrong and it took me 5 minutes and this was like my best example of what not to do on a test. Don't spend 5 minutes getting a question wrong. You know what I mean? You kind of know it or you don't know it and you got to move forward. The answer's not going to fall from the sky and you don't want to waste time and impact future questions. But I had this backwards on test day and I picked that they'd be held to the standard of care of an amateur skier. But you do not get a reduced standard of care for being shitty at something. You will get a heightened standard of care for being an expert at something, right? An expert skier will be held to the standard of care as an ordinarily prudent skier. You do not get a reduced standard of care for sucking at something, but you do get a heightened standard of being an expert. Under doctrine of estoppel by deed, if a party conveys property that they did not own but later inherit or receive the ability to convey that property, the earlier conveyance is prevented from being denied. This question comes up a lot. Tommy conveys a property. It's not Tommy's, it's Tommy's mommy, but then Tommy's mommy dies, and now it is Tommy's, and then Tommy tries to convey it to someone else, he will not be able to. The earlier conveyance will be activated by estoppel by deed. So A knows it's going to receive Blackacre by mommy's will. A conveys Blackacre to girlfriend to impress her. Mommy dies. Girlfriend breaks up with A. A wants to convey land to the new crush. A will be stopped from denying the earlier conveyance. The girlfriend owns Blackacre, right? That's like a very classic fact pattern. It's always about like new girlfriend, old girlfriend. Old girlfriend's going to win because she was conveyed it. And then upon having the authority to convey, it will activate the earlier conveyance. If a federal statute permits jury trials for plaintiffs, be very careful to read the question and see if it's a defendant moving for a jury trial, as they could not do under the statute. Yeah, like some of these questions are fact pattern specific, where it'll be like, under this statute, plaintiffs have the right to a jury trial. And now here, a defendant tried to move for a jury trial. Just a tough question. The Seventh Amendment guarantees the right to a trial by jury at civil cases in federal court for cases at law, monetary relief, also for cases that are triable by jury at common law, such as writ of ejectment. So the Seventh Amendment guarantees the right to a jury trial, like we said, civil cases, monetary relief. A bill of attainder is a legislative act that inflicts punishment without trial. Like if a statute names these professors cannot, challenge the statute and they are punished, that would be a bill of attainder. In a pure comparative negligence jurisdiction, a plaintiff who's any amount at fault, even 99%, can still recover damages, which would be the complete amount of damages reduced by their percentage of fault. So they could recover 1% there. If a party can prove that the courts lack minimum contacts in a pre-entry motion, this case should be dismissed for lack of PJ. The market participant rule is an exception to Dormant Commerce Clause. So if the state owns and operates an oil field, it does not have to comply with the Dormant Commerce Clause, which prohibits discrimination against interstate commerce. Another heavily tested exception to the Dormant Commerce Clause is if the federal government, Congress, expressly authorizes the state to enact the legislation that would otherwise violate the Dormant Commerce Clause. In a race notice jurisdiction, a BFP who records will cut off any rights to any previous interest holder, and a subsequent donee will take upstream shelter in the status of the BFP. If a woman hires a man to kill someone, and the hitman goes to kill the guy, but the guy trips and falls on a rock and dies, and then the hitman shoots the guy in the chest, the woman could not go down for murder because the man did not actually kill the guy. The guy was already dead. The woman could go down for attempted murder because she took substantial steps towards the murder and had the requisite intent. So she tried to kill the guy, but the guy killed himself. Attempted murder, not murder, because you didn't actually have the actus rea. To prevail on a First Amendment claim that a law is discriminating against free exercise of religion, the plaintiffs must show the law is aimed at suppressing the religious beliefs. In order for a court to exercise PJ of a party, they must have minimum contacts. Merely owning a property in a state but having never visited it will not satisfy the requirement. An as-is clause is a valid disclaimer to disclose defects. So if a property is sold with an as-is clause and a warranty deed is delivered and there turns out later to be termites, they cannot sue for breach of contract for failure to disclose. And it would be too late, right? You have to sue under the warranty at that point, and they told you as is. Firing shots into the air, even with no intention to kill someone, constitutes depraved heart murder because it's devoid of social utility and it's an act of an individual with a depraved heart. A new trial should be granted. The jury would likely be biased by repetitive derogatory comments, and manifest injustice would result. For example, if an attorney calls a defendant a no good meanie face and the judge tells him to stop and he does it again on closing, this could be reason for a new trial. One second. In order to prevail under strict liability relating to injury caused by toxic chemicals, the injury must be a result of the toxicity, not just the slipperiness of it, right? It has to be the chemical nature of it or what's toxic about it. It can't just be like the chemical spilled off the truck and someone slipped on it, right? It's got to be that someone inhaled the toxic fumes. A reading of a license plate number as the car speeds away is likely admissible as a present sense impression. Additionally, if the person who made the statement accurately recorded it onto a pocket dictation device and currently has no memory of its contents, it may also be admitted as recorded recollection. The president may validly make executive agreements with foreign nations that prevail over state law. Executive agreements over state law, treatises over executive agreements, the Constitution over everything. Treatises will be on par with recently enacted federal law. Whatever was enacted most recently, the treatise or the federal law will prevail. The business record exception to hearsay requires that the notes are made in the ordinary course of business. A proper foundation must be laid for past recollection recorded. He currently has no memory of its contents. It was accurately made, and it was made at the scene. A government employee has First Amendment rights of freedom of speech. They can speak on matters of public concern, but they can be held responsible, discharged, for example, if they communicate an unwillingness to perform their job responsibility. So you're allowed to say, like, I'm pro or anti whatever, but you're not allowed to say, right now, if you were working for the federal government and you said, I will not, you know, carry out any of the ICE mandates. You can't do that because you're mandated to carry them out. You could probably say like, my cousin's from uh, a refugee country and I support her rights, and they couldn't fire you for that because you're just making an opinion about something. But if you say I'm anti this policy and I refuse to enforce it, then of course they could fire you. Dogs barking are not statements that can be considered hearsay. Neither is machine readings like a radar detector. A government program that gives discretion for awarding loans based on the strength of applicants is valid, and there's no right to notice and hearing for those denied the loan. A validly qualified expert witness may make opinions based on his or her specialized training and expertise and experience. Joint and several liability is a default rule. We got that by now. The difference between larceny by trick and false pretenses is larceny by trick, the perpetrator obtains possession, whereas false pretenses, the perpetrator obtains title. It's a good one. Asking a friend for money with the intent to pay him back, but later losing the money on the parlay is not false pretenses or larceny by trick because there's no concurrent intent to deprive and false assertion statement, right? It's not that you later misuse the money, it's that you trick them into getting the money. A person can be compelled to incriminate themselves despite Fifth Amendment protections if they receive use and derivative use immunity. Transactional immunity does not need to be provided. It's pretty rare that they're going to grant transactional immunity. Transactional immunity is more broad. They really need to give use and derivative use. Okay, use and derivative use is protection from the crime. Transactional use is protection from prosecution for any crimes. So that's how they could, yes, you have the Fifth Amendment right against self-incrimination, but if they need you to, they compel you to testify, they have to give you use and derivative use immunity. If a man accused of arson, both evidence obtaining duplicate insurance for motive and threatening to kill the ex-wife for testifying consciousness of guilt are both admissible as mimic exceptions to the general rule that specific acts are inadmissible to show propensity or conformity. The risk of loss passes to a buyer when the goods are delivered to a common carrier under a shipment contract. If it's a destination contract, free on board, and names a destination city, then the risk of loss would pass when it arrives at the destination, not the common carrier. An assignee of a contract is an intended beneficiary who can assert rights on the contract. The difference between assignment and delegation is that assignment is of rights, the right to get paid, for example, and delegations of duties, the obligation to perform, for example. A lack of access claim under breach of warranty must be brought at the time of the recording, or else it is too late because the time for bringing present warranty claims has passed. If a piece of legislation imposes punishment on professors before they have a hearing or trial, this amounts to an unconstitutional bill of attainder. It is not proper to take judicial notice of a conviction simply based on a telephone call with a clerk of the court, as this amounts to relying on hearsay. A certified copy of the conviction report would be proper, most likely as self-authenticating, for example. Yeah, they can't just get information from a call with the clerk for judicial notice of something. Two things that I see tested a lot in my experience: duress versus threat. I mean, duress versus undue influence. Duress is a threat, and undue influence is abuse of a special relationship between the parties. Another thing that I see tested a lot is the difference between judicial notice in civil and criminal cases. In civil cases, if judicial notice is given, they can instruct the jury that they must accept it as conclusive. In a criminal case, if judicial notice is given, they instruct the jury that they may, but are not required to accept it as conclusive. So it's a must standard in civil cases and a may, but are not required, a discretionary standard in criminal cases. Pure comparative negligence, we talked about a lot. Recorded recollection, we already talked about. Accurate when made, no current recollection, made when it was fresh in their mind. A party who properly raised a JMOL may raise a renewed JMOL and a motion for new trial after the verdict. A lot of times that's what you'll do. Standards for new trial, this is a good one. Error during the trial, the verdict goes against the weight of the evidence, juror misconduct, or the verdict is excessive or inadequate. A JMOL, renewed JMOL, is a reasonable person cannot have reached the verdict, right? Strict liability could be based on design defect. They prove the risk of design the product outweigh the utility, the risk utility balancing test. There may be a need for the defendant to show that it was made as safe as possible. Strict liability for proximate defect can be present for intended use or foreseeable reasonable misuse of the product. Using a lighter to burn illegal substances, right? If you use a lighter to burn the joint, that's a foreseeable use of a lighter, right? Deed formalities and a statute of frauds. Identification of grantor or grantee. Legal description of the property being conveyed, identification of grantor and grantee, legal description of the property being conveyed, words indicating that the conveyance and signature of the party to be bound. um, that contracts in consideration of property sales need to be in writing under the statute of frauds. If they grant this property to all of the if they grant this property to all of the you know church leaders in New York City that wouldn't properly identify the grantee, and if they identify you know it's a tough question, but if it's like a small discrepancy where we get from one fence to the other fence and we say it's 100 acres and it turns out it's only 99.8 acres. Are they going to give you 99.8 acres or fence to fence? The majority rule is to give you the fence to fence because that's more likely what the parties actually meant. If it's a significant discrepancy, then it'd probably be a mutual mistake. Okay. Under the equal dignities rule, when the act performed by an agent is required by law to be in writing, the agent's authority must also be in writing. Therefore, an agent signing a deed on behalf of a principal must have his or her written authority. Okay. When act performed by an agent is required by law to be in writing, the agent's authority must also be in writing. The agent signing a deed on behalf of a principal must have his or her written authority. Think about that as like an executory executorship almost for statute of frauds, contracts in consideration of marriage, contracts for that cannot be completed with 1 year, contracts for land, executorships goes over $500, and suretyships. Contracts that cannot be completed with 1 year, it's from the day the contract is formed, not the date where performance begins. So if me and Tommy agree, for a 1 year contract that's going to start in 3 months, that has to be in writing because it can't be completed for 13 months unless he accepts it. If I say, hey, this is the offer, and you accept it by showing up, and he accepts it by showing up, that's when the contract is formed. And then if it's only 1 year, it doesn't need to be in writing. A 365-day contract doesn't need to be in writing. A 366-day contract doesn't need to be in writing if it's a leap year. Don't quote me on that. But point being, like if it's exactly 1 year, it doesn't need to be in writing. If it's over 1 year, it needs to be in writing. Don't even ask me about the leap year thing. I should not have said that. All right. A design defect occurs when a producer, distributor, retailer, manufacturer, wholesaler, supplier place a defective product in the stream of commerce, and anyone downstream can be held liable. An organization that is private and substantially intertwined with the government is not subject to government scrutiny and cannot have a policy of only male leaders. Can have a policy of male leaders. Just being allowed to use a public facility and the group invites the public is not enough for there to be state action. Right? Be careful to ascribe private action to state action. Just because they're getting some funding from the state or they're using a state facility doesn't mean it's state action. It has to be under state discretion and control. In order for there to be a merger of an easement, the adjoining properties must be held in common ownership and fee simple. If property A is owned by Tom and Tom has a life estate in adjoining property B, there's no merger because Tom does not have fee simple in property B. Right? So a life estate is not they would have to have it fee simple and they can merge it. So A and B, there's an easement A over B, and then A buys property B, that would merge the easement. So then if A sold the half to C, there would be no easement because it was terminated by merger. A homeowner's duty not to burn the house does not extend to a duty to provide shade for the neighbor. If a man is sleeping and the cops bust in with guns drawn and start asking questions, it is likely that the man was in custody and Miranda should have been given before custodial interrogation. If you file suit against someone and are worried they will not be able to pay the final judgment, the best motion is a motion to attach to their assets. Public employees may speak openly on matters of public concern, subject to a balancing test of how it affects their public office abilities. We talked about that earlier. Full faith and credit prohibits states from relitigating cases in which courts of another state have rendered a final judgment. But if you kidnap and you travel from A to B, that's kidnapping in both states. So you could be convicted in both states. It's just like, a contract claim that was litigated in state A. You can't bring that same claim in state B because they'd have to recognize the full faith and credit of the other state. Excited utterance or present sense expression is an exception to hearsay. Typically, excited utterances will end in an exclamation point on the test, but it has to be in the heat of the moment. It can't be like 10 hours later, Tommy screamed something out in memory, right? It has to be, present sense impression, excited utterance at the scene of the incident. Attorney-client privilege will not apply to recordings that are played to third parties. So that's a way to destroy attorney-client privilege. Prior inconsistent statements may be used to impeach. They may also come in substantively if they are made under oath. A party cannot recover for materials purchased after a clear repudiation because it was unreasonable to buy additional materials at that point, right? Like once another party is repudiated, you can't go out and buy more materials for the project because it was unreasonable to buy them. So you're only going to be able to recover for what you got before the repudiation. If a man brandishes a knife at a student and the student draws his gun and shoots back, the student should be successful in a claim of self-defense for murder, right? Because, you're under reasonable threat of um, great bodily harm, right? You can meet deadly force with deadly force. You just can't meet regular force with deadly force, so that would be imperfect self-defense and would probably give rise to a voluntary manslaughter claim. An installment contract is an exception to the perfect tender rule where there will be an opportunity to cure. However, the cure will be too late. The non-breaching party may be entitled to reject the shipment. Photographs are admissible if helpful for the jury and authenticated, but it's pretty easy to authenticate a photo. We just need a witness to testify that it's accurate. If a kid makes fun of a teacher and lies, and the teacher later commits suicide, the best argument the kid has against manslaughter is he did not commit an act that was the proximate cause of the death. And then the 12 beat fences, 1, 6, and 7 can be brought at any time. SMJ can even be brought on appeal. So 1 is SMJ, 6 is fair to state a claim for which relief can be granted, and 7 is fair to join necessary or indispensable party. 2, 3, 4, and 5 must be brought at the first response of pleading, PJ, venue, service, and process of service. So, I only went over the all subject part of this master cram guide. I would definitely go over everything, from the beginning. To me, this master cram guide is the best resource because it's just right to the point, right? Just hit me with the facts, just the things you really want to memorize in order to really crush this exam. So, also, as you guys probably know, we have done our own master cram guide this administration, and um, I want to take a look at that while we have it. So even before we do that, though, let's take a blast from the past and look at the July cram guide. So I don't know if these are going to be the same points that we mentioned. If they are, I'll skip over it. But we have the master cram guide, we have the July cram guide that I made last administration, and so you see, same thing. You can, if you have access to all of these. Okay, so I think these are new. So let's go over these new points. So in a pure comparative fault jurisdiction, a plaintiff may recover the total amount from the defendant minus any percentage of liability attributed to him. The psychiatrist-patient privilege covers communication made in the course of treatment or diagnosis, but would not protect a statement to a nurse that he planned to shoot the president when she came to town. A bona fide purchaser is someone who takes for value in good faith and without notice. In the majority of jurisdictions, and to be assumed unless the language of the recording statute explicitly states otherwise, a judgment creditor is not a BFP. If the jurisdiction expressly protects judgment creditors, then a judgment creditor without notice will prevail just as a BFP would. If a statute allows for a judgment to operate on a lien against real property then owned by the defendant or subsequently acquired, this judgment will not apply to properties that were conveyed before the judgment was rendered. So a lot of stuff about the notice jurisdiction and, pure notice, subsequent BFPs will prevail. Race jurisdictions, first to record will prevail. Race notice, the first BFP to record will prevail. Typically, a judgment creditor is not a BFP unless the language of the recording statute states that they will. And if they do protect judgment creditors, then a judgment creditor will prevail just as a BFP would, if that jurisdiction provides for it. So, for those questions, make sure you read the statutes carefully. If an owner conveys a life estate and dies, the ownership rights revert back. If another party then charges a tenant rent and collects for the statutory period for adverse possession, he could prevail as a new owner because the tenant's hostile use of property will be attributable to the new landlord. While most gift promises are not enforceable, sometimes they can be under a theory of reliance if it's necessary to prevent injustice. A party may plead the fifth, the right against self-incrimination, in a civil or criminal case. In a civil case, an adverse presumption may be made by the jury as a result. No presumptions based on the use of the right against self-incrimination may be made in criminal court, right? So you can't make a presumption in a criminal case. You can make a presumption in a civil case, like, oh, he pleaded the fifth. That means he probably did it. Okay, in a civil case, that's fine. Not in a criminal case. Once a clear repudiation has been made, the non-repudiating party is not privileged to buy additional materials. So we talked about that already. For example, if A and B agree to a construction job and A expects $3,000 profit and B repudiates, then A goes and buys $5,000 worth of materials for the job. The damage will be limited to $3,000 because it's not reasonable to buy the additional materials after the repudiation. A person of unusual sensitivities will be precluded from recovery in a private nuisance claim. For example, old people who like to nap during the day cannot recover against their neighbors whose children play loudly in the pool during the daytime. If a state law requires that any person found guilty of misprescribing drugs shall lose their medical license, A man who's found guilty in court for misprescribing drugs does not deserve a notice hearing with the medical board because all the adjudicated facts necessary to result in his license revocation were fulfilled at trial. So you don't always get this right to a notice in a hearing if they've already properly adjudicated it in a different trial. You already had a notice in hearing. If one party sends a contract to another and the other party sends back an identical contract admitting one term, this is likely concealment and the fraudulent party will not be protected by their actions, right? We're going to look to punish actors in bad faith on the MBE. The contract clause only applies to existing contract. A woman who wants to be a ski instructor but has to take a course, pass a test, and pay a fee does not have a claim under the contracts clause because although her right to contract with the state is being impaired, she does not have an existing contract and therefore cannot make a claim under the contracts clause. I remember that being a tough question. If an employee of a company that is a party to a case makes a statement, "I'm sorry for what I did," that statement can be used against the company as a party opponent agent. A witness who is testifying on behalf of a party's reputation for honesty can probably be asked if they ever heard that the party was disciplined for cheating in medical school because it's relevant to the credibility of the witness. We can always ask about truthfulness on, cross of a witness because their ability to testify truthfully is at issue. The best evidence rule applies to writings, recordings, and photographs, not models of robots, for example. A motion to transfer is more likely to be granted than a motion to dismiss for form non-convened. So they say which is more likely to be granted? It's going to be the motion to transfer. So for example, the location is the more likely option because form non-convenes means a dismissal and a refiling, where a motion to transfer just means we're going to transfer it to another appropriate jurisdiction. Knowing concealment can constitute fraud. If a person contracts for a job and the other party repudiates, the non-breaching party has a duty to mitigate. So this is what I talked about. For example, if a teacher's offered 50K and then the school repudiates or damages her 50K, unless there's another job available as a teacher or she takes another job. In either of those cases, her damage will be 50K minus the new salary. She does not have to take the other teacher job, but she can only recover the difference in salaries. She does not have to take the other job, but if she does, her damages are limited to the difference in salaries. So I talked about that. If there's a comparable job, it's the difference in salaries. If there's a non-comparable job, it's the difference in salaries if you take it. If there's a non-comparable job and you don't take it, then it's the total contract price because you had no duty to take a non-comparable job. If a buyer and seller agree to a $10 widget sales price and it costs the seller $8 per widget to manufacture and the buyer repudiates and the seller finds a salvage buyer for $2 per widget, the total damages are $8 per widget because it's the correct measure of expectation damages, right? You won't be doubly enriched. It doesn't matter what your manufacturer price was. It matters what your sales price is, what you expected to profit. You thought you were going to get $10, but then you ended up selling them for $2. So you can get to $8 because that's the difference in what you expected to sell for and what you sold it for. How much you produced it for internally, that doesn't matter, right? Like my in-house cost of productions have no weight on my expectation from my sales, right? I don't want to look at my in-house cost of production. I'd probably be running at a loss. Putting a foot in the window still constitutes entry for the sake of burglary. Therefore, if Susie put her foot through the window with the intent to steal the necklace, but a dog started barking, she'll be found guilty of burglary. Judicial notice may be taken at any time in a proceeding, even on appeal. The First and 14th Amendment do not deprive an entertainer of the value of their commercial activity. An entertainer has a right to publicity, which means they can prohibit people from taking pictures inside the venue and broadcasting it. Conspiracy at common law requires a bilateral agreement. So if you cannot conspire with someone who actually is planning to turn you into the police. However, the person with the guilty mind could be convicted of solicitation. An oral rescission of a land sale is valid. For instance, if two parties orally agreed to rescind the land sale and one of the parties agrees to sell the land to a new party, this was a valid reliance on an oral rescission of a land sale contract. Unless specified that an offer can be accepted by performance, it can be accepted expressly or by beginning performance. And if accepted by beginning performance, the offeree must notify the offeror within a reasonable time that she's accepted by beginning performance. Failure to correct a previous disclosure constitutes non-disclosure and therefore is a basis for fraud, right? You have to correct it. If you say that you make this much money, but then you lose your job and then you don't tell the loan application company you lost your job, that would be a basis for fraud because you failed to correct. Same with applying for the state bar exam. If you tell the Board of Bar Examiners you've never been arrested and then you get arrested, you pull a Shia LaBeouf over Mardi Gras weekend, then you have to tell them that. A defendant's counterclaim does not transform a plaintiff into a defendant for removal purposes, right? Like they're still a defendant and only defendants can remove. Look for that. Defendants can remove and the forum state defendant rule. A defendant sitting in diversity, so in diversity cases, not federal question cases, if they're trying to remove upward in their own state, they're not going to be able to do that because they're already getting the benefit of being in their own state. If they're sued in the plaintiff state or they're sued in another defendant state, then they could remove. But you can't remove upward in your own state for diversity cases under the forum state defendant rule. Oh, that's why I said right here. The forum state defendant rule applies when the original claim is based on diversity, not where there's a federal question. A dentist is a user for the purpose of strict liability, not a manufacturer, retailer, producer, distributor, supplier, and therefore cannot be held liable for statute of limitations for faulty hypodermic needle. Further, a dentist who uses due care cannot be found liable for malpractice. Talked about pure comparative negligence already. In pure comparative fault jurisdiction, contribution will be a basis for reduction liability, but not a bar to recovery. A stronger argument is that no duty was breached because the child should have understood the risk associated. Right? They didn't breach a duty. The child could read and they put a warning for him. Delivery occurs when there's present intent to transfer and acceptance. There's no need to be a recording to establish delivery and transfer, right? Delivery occurs when it's left their control. If you have a reasonable basis for shooting someone, adequate provocation to shoot a man, and you shoot his twin brother, reasonably believing it's the right person, the instruction for voluntary manslaughter is proper. A variance is when a party is permitted to do something different than Zone 4. A non-conforming use is when someone is grandfathered in to do something after the zoning laws change as they were doing it before. So you're grandfathered in for non-conforming use. And amortization is conforming a non-conforming use over time. A seller of a defective lighter can be held strictly liable if the lighter explodes in someone's pocket. A third-party complaint that brings in a new defendant does not give the new party the ability to remove. Only the original defendants can remove, not those that are brought in via third-party practice. Procedural due process requires notice, pre-termination hearing, and post-termination evidentiary hearing. Under the full faith and credit clause, one state must honor the judgments of another state so long as there was jurisdiction, judgment on the merits, and a final judgment. The crime fraud exception to the attorney-client privilege is an objective standard, not a subjective one. It does not matter whether or not the attorney knew of the legal purpose behind the communications. We said the best evidence rule is not apply to robots, just documents, x-rays, recordings. Parole evidence is admissible to clarify an ambiguous term. Restraints on alienation are void as a matter of law. For example, if A conveys property to B, but there's a condition that B cannot sell the property for 10 years, this is an invalid restraint on alienation and precludes the property from being marketable. A jury may not bring a learned treatise into a jury room because of the risk of reading non-germane parts. It may only be read by counsel or an expert witness to the jury. That's how you bring a learned treatise, by reading it in by counsel or an expert witness. If a defendant sued by two defendant plaintiffs and the facts show that they have separate unrelated injuries, the proper motion to file is a motion to sever and order the plaintiffs to bring different lawsuits. The Supreme Court has ruled that a party could be found jointly and severally liable is not a required party. Just because they could be found jointly and severally liable, that doesn't make them a required party. For the sake of issue preclusion, successive landowners are said to be in privy with each other. Therefore, a subsequent landowner can assert issue preclusion in the same capacity as a prior landowner, regardless if the question mentions mutual or non-mutual issue preclusion, because they're in privy and essentially the same parties. Privy for claim preclusion could be an employer-employee relationship. A special verdict is an indicator of issue preclusion because it shows the issue is actually litigated, whereas a general verdict would not give rise to issue preclusion because it wasn't actually litigated. If A conveys a life estate to B and then A dies and leaves the property to C for life, and then D, the death of A will not strip B of B's life estate. When B dies, the property will go to C for life and then to D, right? The measuring life gets to keep it for their life. The life estate tenant gets to keep it for their life. If a defendant fails to respond to a waiver of a service request, the plaintiff must actually serve them to effectuate proper service of process. Just because you didn't waive service doesn't mean that you've been served. Now they have to actually serve you. You might have to pay the fees for failing to waive service, but you haven't been actually served until you've either waived service or you've been served. PJ based on minimum context is a two-part test. It must comport with due process and the state's long-arm statute. For example, the Supreme Court rules that a single sale is enough to establish minimum context, but the state long-arm statute does not permit PJ based off a single sale. There'd be no PJ in a federal state court in a diversity case because there's no basis under the long-arm statute. So it has to comport with due process and the state's long-arm statute. If a defendant opens the door by having a witness testify to the honesty of the defendant, the prosecution may rebut with specific instances. For example, asking the witness if he had ever heard the defendant was arrested for embezzlement 2 years ago. They've opened the door, and now we can bring in that character evidence and ask about specific instances. Whether presumption applies is determined by state substantive law and diversity case. So damages, presumptions, statute of limitations, those are substantive issues, or actual, elements of the claim. Those are substantive issues. Procedural issues are like order of order of witnesses or order of presentation or transfer venue laws or whether a party has to submit to an expert examination. Things like that would be procedural. Once a deed has been recorded, the obligations of the contract merge into the deed, and it's too late to sue for breach of contract claims, except for fraud or concealment. A forged release of a condition on property in a recording is ineffective, right? A forged release is ineffective. A lessor must warn a lessee of dangerous conditions on property, including latent defects that the lessee would not be aware of. If a party moves for summary judgment and its affidavit shows there's no genuine disputed material fact and it's indisputed, then summary judgment should be granted. If a person is sued for breach of contract and they have an affirmative defense that they were a minor at the time of the contract, this defense should be pled in answer. It is not the basis for 12b6 failure to state a claim motion for dismissal because there is a claim, there's just an affirmative defense. So affirmative defenses are not the same as failure to state a claim. Affirmative defenses mean like, yes, the claim is true, but I have a affirmative defense. 12b6 says that's not a claim of action for which relief can be granted. They're a little bit different. Voluntary motion to dismiss versus notice of dismissal. Both ways to dismiss and refile. However, notice of dismissal may only be made before the defendant answers or moves for summary judgment. So after that, it would have to be a voluntary motion to dismiss. If a defendant played a video recording of a conversation they had with his attorney to his father to get his father reactions, the tape would not be considered confidential as it was shared with a third party. It's more convenient to file a 12b motion to dismiss for lack of PJ than to file an answer with an affirmative defense for lack of PJ. Yeah, because you don't have to file the answer, you just file a 12b motion to dismiss. For minimum contacts, there must be relatedness. For example, a subsidiary that ends up with 2% of its tires in America could not be sued in America for an incident that occurred in Europe because the minimum contacts test has not been met, right? The parent company wasn't operating in America. It was just the subsidiary, who's a separate entity from the parent, had the contact with the country. In diversity case, in accordance with federal common law, the second court should apply the preclusive effect of the first state where the claim was decided. I feel like I talked about this one a lot, so it's a tough concept, but hopefully repetition is helping here. For example, if A sues B in federal court in state A under diversity, and the claim is involuntarily dismissed, and in state A, this does not operate as adjudication on the merits. Then the preclusive effect will be that the case can be refiled in state B, even if state B involuntary dismissals operate as adjudication on the merits, because the preclusive effect will look at the first court where it was filed, and they sued him in state A court. So here we're going to look at the state A preclusive effect to see if it could be refiled. So, again, I didn't go over all of these, but it's in the classroom that you guys have access to the July 2025 Master Cram Guide. And I recommend you go over the complete Master Cram Guide, the July 2025 Master Cram Guide, and then the most important one, I'd say, would be the one that we're doing this administration, because it's it should be easy to refresh, right? These are concepts that we've made as a class, and we're going to add a few more today. But yeah, these are concepts that we made as a class, so you should, have familiarity with them based on, oh yeah, I remember doing that actual question, and so that should help trigger the memorization of it all. So you see, the way that I operate, I'm always building on what I've done in the past and giving my students more than they've ever had before. So that's why I always expect my students to do better than they've ever had done before. And my students have been crushing this test for a long time. So I'm very confident y'all are really, really going to crush this test. All right. A prior inconsistent statement is only admissible if the declarant had an opportunity to explain or deny a statement. For example, if a woman says the light was red at trial, but is not subject to cross-examination and then unavailable, an alleged inconsistent statement where a neighbor says that she said the light was yellow is inadmissible because she's not have a chance to explain or deny a statement. Usually we're bringing these statements against interest against people while they're on the stand. I mean, usually we're bringing these prior inconsistent statements up against people who are on the stand, right? So it's like they're available, right? That's why we're bringing it in. But if they're unavailable and there was no opportunity to cross them in a previous court appearance, then we can't bring in the prior inconsistent statement. But typically on the test, the prior inconsistent statement can come in for impeachment, and it can come in substantively for if it was made under oath, because typically it's to impeach someone on the stand with a prior inconsistent statement. The states are allowed to indirectly tax the federal government. They just cannot directly tax the federal government. For example, a state can tax an antique salesman who is a collector that works for the federal government. A criminal act typically supersedes the negligence of a party, unless the party created a condition that foreseeably invited the crime to occur. For example, if a gun store owner leaves the alarm deactivated and someone steals a gun and goes on a shooting spree, this would be a superseding act unless there's evidence that the shooting was foreseeable, such that is a high crime area with many shootings. If the cause of action is battery, the best argument for holding a child liable is that the child had the requisite intent to constitute the battery. A JMOL will not be granted if there's evidence supporting both sides because a reasonable juror could find for either party and there's substantial evidence supporting either side. If a party that is secondarily liable makes payment on a mortgage, that party can seek reimbursement from the primarily liable party under the rules of suretyship. So remember, expressly assume the new party becomes primarily liable, subject to the new party becomes secondarily liable. But in both those situations, there's a surety, either the original party if it's been expressly assumed, or the new party if it's been taken subject to. And in those cases, if the secondary liable party makes the payments, they can collect from the primarily liable party under the rules of suretyship. If a contract has a condition that a payment is due upon reasonable satisfaction with the project and Karen is not satisfied, she does not have to make full payment because the condition was not fulfilled. She was not satisfied. A writing will satisfy the statute of frauds if it identifies the terms of the contract and assigned by the party to be charged, even if it's not made contemporaneously with the agreement, right? As long as it's made afterwards, it's still fine. There's no reasonable expectation if the marijuana plants can be seen from the neighbor's vantage point. Evidence of bias is admissible to impeach credibility. For example, evidence that the person belongs to an anti-military group who is accusing the military of wrongdoing. Definitely looking for this evidence of bias to be admissible. The trial judge has broad discretion over the order of examining witnesses. Warranty disclaimers are material alterations that will not be included in a contract if they are added as an additional term in acceptance. For example, an acceptance that disclaims consequential warrant damages will not alter the terms of the contract. You can get consequential damages even if they try to say that you can't in an acceptance because that would be a material term and the UCC expressly provides for consequential damages. Specific performance is appropriate when legal damage would not suffice. For example, a breach of an agreement to pay someone for the remainder of life would justify specific performance because it's not possible to estimate how long they will live and what the total payment would be. The proper remedy would be specific performance to enforce the payments to be made. A deed must properly identify the grantees. For example, a deed that conveys property to my neighbor is invalid if the grantor has neighbors to the east, west, and south. In order to subrogate a mortgage, the purchase mortgage must be originally senior. There must be no countervailing inequities to the other mortgage, which is being skipped over in priority. It must be appropriate to revive the purchased original senior mortgage in favor of the purchasing mortgagee, known as subrogation. So that's just tough concept, and you need those elements for subrogation. A person with personal knowledge can testify to the sound of a voice seeming to be the defendant's, even if they're not certain, because the way the testimony is for the jury. There's no privity between a landlord and a sublessee, so the landlord can only collect from the sublessor, the original tenant. A sublease is an interim lease, year 2 of a 3-year lease, whereas an assignment is a durational lease, year 3 of a 3-year lease. And if there's an assignment, then there's privity between the landlord, the assignor, and the assignee, and the landlord could collect from either of them. Res ipsa loquitur is appropriate if the injury would not have occurred in the absence of negligence, and the injury causing instrumentality was under the exclusive control of the defendant. If a court dismisses a case sua sponte for lack of prosecution, this will be considered adjudication on the merits and will prevent the claim from being refiled. That was a tough one, but if the court dismisses on its own for lack of prosecution, then it's assumed with prejudice and it will be an adjudication on the merits and prevented from being refiled. Similarly, if someone voluntarily dismisses a claim twice, then it'll also be barred from being brought again. A party that assumes the risk of a mutual mistake will be bound by the mistake. For example, if a breeder buys a young boar 2 months old and it's not possible to know if the boar will be sterile or not until 12 months, later finding out the boar is sterile is a risk the breeder assumed. If A conveys land to B for life and then to C's heirs and assigns, then this is a remainder subject to open. And if C creates a will leaving his estate to D, then D takes the estate after B's life estate because B for life and then to C's heirs and assigns. C has assigned his estate to D, so D is going to take. The measure of damages for shipment of non-conforming goods would be the listed price for sale minus any additional damages incurred as a result of the non-conforming tender. So this is the Cram guide that we made this year, and we're going to continue. We'll add a few points to it. I have the July Cram guide in the course, and then I'll make sure that you all have access to the Master Cram guide as well. I just want to do a couple questions together, and then I'll stop the recording, and as a class, we'll do like a quick set of 10 questions and add 10 more Cram guide points to the Cram guide. But I just wanted to go over some questions together and just kind of show you an idea of what you might want to do, you know, Tuesday night, Wednesday morning, because you really don't want to you don't want to psych yourself out. You want to do things that are nice and easy and things that you could get right based on them being ascertainable and confidence building. So I think a really great place for that would be on our Q bank Birdie, right? The concepts questions. I might just do these lightly and be like, can I get most of these questions right? Because these aren't like our, NCBE like questions or our tough test questions. These are ones that are just reinforcing some key points. So I'm just gonna go over a few of these and then I'll stop the recording and then we'll do some live questions together to end the February 2026 study administration. So F hires G to renovate his kitchen for 10,000. After completing the work, G demands an additional 5,000, claiming that the project was more difficult than he anticipated. Can F refuse to pay the additional amount? Yes, because the additional payment was not part of the original contract. No, because F received the benefit of G's work and should pay him for it. No, because G has the right to demand additional payment for unforeseen difficulties. Yes, but only if F can prove that the additional work was not necessary agreed upon. Here, the answer should be A here, where you can't just demand extra money. Now, if you agree upon it or there's modification or there's something of that nature, then maybe, but you can't just demand it. And for these concept questions, I think I have, the explanations, right? Like my own explanations. Unless the parties agree in good faith, an additional term cannot be unilaterally added to the contract after performance. The parties must abide by the express terms of the agreement. So let's do another contracts question. John sends a letter to Jay asking to clean the house for 200. Jane mails an acceptance letter to John, but then John calls Jane to cancel his offer, unaware that she mailed the letter. Here, this is a mailbox rule, right? Can John argue that there's no valid contract? Yes, because John never knew about the acceptance, so there was no meeting of the minds. No, because Jane received the offer and wrote an acceptance letter. No, because Jane put the acceptance letter in the mail. Or yes, even if John knew about the acceptance letter because he never received it. So here in the mailbox rule, it's not just because you wrote it, it's because you put the acceptance letter in the mail. So under the mailbox rule, acceptances are valid once placed in the mail. This is because a meeting of the minds has occurred as of this moment, right? The offer has been made and the acceptance has been granted. So I really recommend going over some of these concepts questions just because they could be, helpful in reinforcing some of the main rules. So pet shop sells exotic pets, including venomous snakes. Jane purchases a venomous snake from pet shop and escapes from her home, biting and injuring her neighbor. Which of the following is the most likely basis for the neighbor's claim against Jane? Well, remember, a snake is a wild animal. So here we would have a strong argument in strict liability because there's an injury that, was the result of a wild animal. Snakes are considered wild animals, and when a snake causes injury, the snake owner will be subject to strict liability. Let's try con law one. What's the main difference between Article 1 and Article 3 courts? Okay, it's a good question. Article 1 courts are established by Congress, where Article 3 courts are established by the president. Article 1 courts are allowed in the Constitution, whereas Article 3 courts are not. Article 1 courts have broader jurisdiction than Article 3 courts. Article 1 courts are created by Congress and have limited jurisdiction tenure, while Article 3 courts are created by the Constitution and have broader jurisdiction and life tenure for the judges. That's correct. Article 3 courts are the Supreme Court and things like that. They're established under the Constitution with judges who have life tenure and side protection, and they handle a broader range of federal judicial matters. Thus, the main distinction lies in the origin of judicial protections and the scope of jurisdiction. So, see if I have a explanation for that. Article 3 courts are true judicial courts with broad jurisdiction created by the Constitution, such as the Supreme Court. These judges have lifetime tenure. Article 1 courts are much more limited in scope and are created by Congress. There's no unlimited tenure in Article 1 courts. For the United States court to review a case, which of the following requirements must be met regarding the decision of the lower court? The lower court's decision must be final and not subject to further appeal within the lower state's court system. The lower court's decision must be unanimous. The lower court's decision must affect all states equally and simultaneously, or lower court's decision must have been appealed directly from a state Supreme Court. It doesn't have to be directly from a state Supreme Court. It just has to be a final decision and not subject to further appeal within the system. So for that one, only final judgments are appealable on review by the Supreme Court. Otherwise, they could file like a writ of certiorari to get straight to the Supreme Court, but it has to be a final judgment for it to be appealable by the Supreme Court. So John grants a property to his daughter Susan for her lifetime and then to her eldest son Robert. Which type of life estate does Robert hold in this situation? Okay, Susan for life, and then to Robert. Robert is going to have a remainder. Is it going to be contingent or vested? It's going to be vested because um, life is certain to come to an end. So for this one, a remainder follows the life estate. The term vested means that's unconditional. The remainder man is guaranteed to receive the property in a fee simple eventually. Well, what if the eldest son dies before Susan? Well, the eldest son's Robert's estate would still take. So it's still vested in him and his estate. Um, let's try some civil procedure ones. Just this is the type of stuff I would do before the test. Like obviously do everything you can to feel good, but if you just want to warm yourself up the morning of the exam, it might be good to run through these concepts questions just to reinforce some, black letter law and to build confidence in that. I would do them before, like don't make it the first time you do it. You want to get the questions right. You want it to be reinforcement that, you got some things nailed down, right? So plaintiff, a resident of state A, files a lawsuit against defendant, resident of state B, in federal court in state A. Plaintiff's claims arise from breach of contract and they seek $120,000 in damages. Defendant argues that federal court lacks SMJ. Well, it's A versus B, it's over 75,000, so I think we're going to be fine. So is the defense argument likely to be successful? Yes, because the parties are not diverse. Yes, because the amount of controversy does not meet the diversity jurisdiction threshold. No, because the court has diversity jurisdiction based on the party's citizenship and the amount of controversy, or no, because the federal court has supplemental jurisdiction over the claim. So here, I think this one is, proper diversity jurisdiction based on the amount of controversy and the fact that they're from other states. An attorney files a complaint on behalf of a client that contains allegations that are not supported by any factual basis. The opposing party serves the attorney with a motion for sanctions under Rule 11, but does not immediately file the motion within the court. What is the purpose of the opposing party's delay in filing the motion for sanction? So here, you can't file the motion for the court because you have to give them 21 days to amend, to retract, to correct their insufficient allegation here, right? So to provide the attorney an opportunity to withdraw or correct the allegedly frivolous complaint under safe harbor provision, 100% correct. To allow the court to review the motion for sanctions in camera, to give the opposing party time to gather additional evidence in support of its motion for sanctions, or to provide the attorney an opportunity to file a motion for summary judgment. So definitely here, there's going to be a safe harbor provision. Remember that you have 21 days to withdraw or correct a challenge pleading under Rule 11. Check out maybe evidence question. So what's the purpose of the hearsay rule in evidence law? To ensure that only qualified experts testify in court, to ensure the reliability and accuracy of evidence presented in court, to prohibit the introduction of prejudicial evidence that's not relevant, and to limit the scope of cross-examination by opposing counsel. Here, it's going to be to ensure the reliability and accuracy of evidence presented in the court, because we want to have, evidence that we are sure is accurate. Whereas C right here, to prohibit the introduction of prejudicial evidence that's not relevant, that would be the 403 balancing test. The hearsay rule is to make sure that we have reliable and accurate testimony. Let's try one more. So which of the following is an example of a hearsay evidence? Testimony from a witness who personally observed an event, a document that was signed by the defendant, a statement made by a person who is not available to testify in court, or expert testimony on a technical or scientific matter. Statement made by a person who's not available to testify in court. I mean, that sounds like the best answer here, right? I was thinking like maybe it's an exception to hearsay if it was X, Y, or Z, but they weren't asking this. It's a concept question. It was just saying that would be, it's an out-of-court statement proffered into evidence in order to prove the truth of the matter asserted. And then, see, criminal law concepts. In which of the following situations would the defense of necessity likely be successful? A person steals food because they're hungry. A person breaks into a house to escape a sudden and severe thunderstorm. A person drives with a speed limit because they're late for work, or none of the above. I mean, probably this one that, yeah, it's, significant. I mean, that's a tough one. You could argue that you can't just break into the house. You should just hide on the porch. But maybe if it was sudden and severe, and you needed to, there's no lawful alternative. Which of the following is a specific intent crime? Trespass, battery, burglary, or false imprisonment. I would say burglary is the best case here because you have the specific intent to commit the felony or theft inside, not like exactly which crime you're going to commit, but the intent to commit a crime inside. So Detective Martin obtained a warrant to search Carla's house for stolen property related to a series of burglaries. The warrant specified that the search should be conducted between 6 a.m. and 10 p.m. The detective arrived at 10:30 and conducted a search finding stolen property. Carla moves to suppress the evidence. Will the court grant the motion? Yes, because the search was conducted outside the specified time frame. Yes, because Carla was not notified about the search beforehand. No, because the search was only slightly outside the specified time frame. Or no, because the warrant was still valid at the time of the search. Um, it's a tough question. I mean, I think that there's a argument here for uh, there's definitely an argument for B because Carl, no, there's definitely an argument for C because it was only slightly outside the specified time frame. But then there's an argument for A because it was outside the specified time frame. Does anyone want to help me and think that they know the answer to this question? Let's see what we're saying in the chat. Tough last question, right? Um, yeah, people are saying A is definitely A. Right, because it was conducted outside the specified time frame. So it has to be within the time frame. Good question, tough question. But again, if you do these, over and over, then you should be able to get them right just based on repetition, and it can reinforce some rules. Officer Lopez arrested Tim for assault and placed him in the back of a patrol car. Before reading Tim his Miranda rights, Officer Lopez asked Tim if he had any weapons on him. Tim responded that he had a knife in his pocket. The officer then recovered the knife. Tim moved to suppress the knife as evidence. Will the court grant his motion? Yes, because he was not read his Miranda rights before being questioned. Yes, because Tim was in custody at the time of the questioning. No, because the question was related to officer safety, or no, because Tim voluntarily disclosed the information. What do you guys think about this one? Yeah, I think that this one's related to officer safety. He said, "Do you have any weapons on him?" So usually, you can give Miranda rights if you're going to ask a custodial interrogation, but here this one was related to officer safety. So, yeah, really good things to do. And even for me, I feel like Crim Pro, I could do those concept questions one or two times before the test just to make sure that I got them all down pat. But yeah, I really recommend that you guys do cram guides, cram guides, cram guides. I recommend that you do some of those concepts questions and just keep studying as hard as you can. What I'm going to do right now is add the February 2026 points to the master cram guide. I'm going to consolidate all that and you'll have access to it in the classroom. But if you want to stick around after the recording, we're going to do 10 live questions together on the polling feature to just complete the cram guide for the year. My final advice to everyone is you got this, be confident in yourself. You don't have to get every question right. You just have to try to finish on time, put your best foot forward, and choose the answer that most correctly answers the question being asked and properly identifies the issue. Wishing you all the best of luck on test day. I'm going to stop this recording.